Good morning. Welcome to the Courtroom Files Live. You are looking at Judge Middleton's court in Centerville, Michigan, where earlier this morning he had a zoning hearing on a house that was condemned, and they're trying desperately to bring it back up to code. So let's listen into that.
Mr. Coleman, it does appear that she's put a new roof on the house. Is that correct? Yes. Doug,
Yes,
it does appear that she put a new roof on the house.
that is correct, Your Honor.
She put a new metal roof on the house. It looks good. And as we all know, you got to fix the roof before you fix any leaks inside. So when was the roof completed?
It's been just, I would say, in the last couple of months. She had a contractor come in and do, I believe, the main house portion. I believe Scott was doing the garage portion. At the last time we were in court, there was just a little bit left where I believe the metal roof was merging with the house, and it appears that that's all been completed.
All right, so she's obviously making good faith efforts to get this property into compliance. We keep losing you.
Yeah, I'm still here. All right.
Uh,
I'm going to leave it alone because I think this is like the ceiling fan that bugs you. If I keep bouncing back.
Well, at least you're not smoking, so we got that going for us. All right, what would you like me to know regarding your inspection of February 10th?
Your Honor, I totally agree. They are doing their best moving forward. So do I believe that they're making progress? Yes, I do. I'm still somewhat troubled, and I'm just going to put it on the record. Do I believe that they're trying? Yes. Is the house unsafe to be living in? The answer is no. Do I believe that they're staying in the house? The answer is yes. You know, when we do a case like this, I'm sure there's people out there on social media that say, and she's doing her best, and just leave them alone. But the minute that something catastrophic happens at that location, you and I are going to get chastised why we didn't do more. I don't have an answer, Your Honor.
We have been there before.
Yes, we have, and it's not a comfortable position to be in. It just depends on what side of the fence you're on. I understand.
All right, would you like to screen share the photos?
Sure, I can share screen. I would just comment that it's certainly better than some people that are living in tents. So, you know,
there is that. She did do a follow-up email, which will address, indicating that she's made even more progress since this inspection. But why don't you go ahead and show us what the status is as of the 10th of March or 10th of February.
So this is inside the house. This is one of the things that does disturb the building inspector and myself. This, I'm going to call it the yellow door behind the refrigerator. That is a door that's separating this house into basically two separate living spaces. On the other side of the door, I'll show a picture later that there's actually a hasp on it that they can put a padlock on it, preventing somebody from getting from one portion of the house to another. This could be a fire trap, along with some other pictures that I'll show you in a minute.
Well, the house isn't zoned as a duplex, is it? It's a single family dwelling.
You are correct. It is a single family dwelling. So the continuance of this door being blocked just cannot happen. This is the living room on the east side of the house. As you saw in the origin, we had leaky roof. She does have a new roof on the outside, and they have put tiles up on the inside to aesthetically make it look more appealing. That's just a closer up view of the ceiling that's been patched. Probably 3/4 of this house still has no ceiling or no insulation in the ceiling. So although it's weather tight, it's certainly not meeting the codes for energy code or a finished house. They've painted the windows. These windows are now painted shut, so they can't open them. So the building inspector has a big concern for emergency ingress and egress in case of fire. Here's an extension cord that's running across the floor, supplying power to the washer and dryer in that room. Again, just another view of no ceiling in the room. This is the same room, and then this window is also got so much paint on it that it could not be opened for emergency exit. This is the bathroom. Again, the window's painted shut and no ceiling in the bathroom area. This is the kitchen area. A very minor correction. If you see this outlet, it does have an open area there where something metal could get in there and cause an electrical shock. This is the bathroom where it used to have a electrical outlet right next to the shower unit. That has been corrected, and the switch is on the other side of the wall now. Here's the other side of that door where the refrigerator's behind it, showing the hasp and lock. There was not a lock on it at the time, but the building inspector says that this type of locking device must be removed from that door. This is the living area on the west side of the house. This area in the background where you see this table and stuff, that's actually a sliding glass door. So that is obstructed from emergency ingress and egress in case of a fire. This is just a picture of the exterior of the house where the roof has been completed. This is the backyard. We indicated before they had some missing fences. The fence is still missing. It looks like they're using this now as a driveway and parking cars behind the house. Although there's no water in it, I do have concern about this swimming pool. As you can see over on the east side of the swimming pool, the actual wall is collapsing, eroding the dirt underneath the cement that's in this area. This is right next to Dollar General. So my fear is some kids could be messing around and end up getting hurt because of this open, unprotected area. And this is just the report from the building inspector. One of the things that, and I understand Jody has taken care of this since, or Scott has, there were no interconnected working smoke detectors in the home when we did this inspection. So that would be an issue that needs to be taken care of before occupancy could be given to this home as well. Again, I think Jody and Scott are doing their due diligence, but we're just not there yet to be able to offer a certificate of occupancy.
All right. Can I have my screen back?
Yes, Your Honor.
Mr. Jarnett, you sent an email dated February 22nd. I'll just read it into the record. This letter is regarding our last inspection, which took place on February 12th. Mr. Coleman, Mr. Belair, Mr. Wiki. We were flagged for several infractions on this day, including a lack of proper interlinking smoke detectors, failed bedroom window openings for emergency exits in both back bedrooms, a padlock adjoining the living spaces. Since then, and this is you speaking, Mr. Jarnett, we have mounted all 6 interlocking smoke and carbon monoxide detectors on both sides of the home. Our padlock has since been removed, and 1 window to each bedroom has now been fixed and are operable for opening for an emergency exit. We are in the process of locating 2 new windows for both of these bedrooms. The windows are very old and desperate, need replacing. I have included before and after pictures. I assume we have another inspection in the near future to finalize all this trauma. I pray we can get this wrapped up and we'll be at a full year of condemnation on April 11th. We'd like to get our lives back to normal as much as possible. So since that inspection, you took care of several of the items that he listed in the inspection. Now, I'm not oblivious to the fact that this all costs money. And putting that roof on was an expense. Buying new windows is an expense. And you're trying to bring this property back up to code. You and your brother got overwhelmed by life and the property just fell into this state of disrepair. But unlike some of the people I see who talk a good game, you're actually doing some things to get forward in the process. And you're right, we're gonna need another inspection. And I try to work with people like you who are doing the best they can to try to get the property back into compliance. But you heard what Mr. Kuhlman said. If something bad happened here, there was a fire because of these faulty electrical boxes or extension cords for washers and dryers.
That's not an extension cord, that is the actual cord that hooks up
Okay,
from the wall
all right.
to the washer and the dryer. They're
if-
connected properly, yes.
Okay, very good.
It's not an extension cord.
Now, obviously, you've got to get a ceiling in here and the
Judge Fleischer has gone live, so we'll go ahead and switch over there. This issue going on in Judge Middleton's court, if you haven't figured it out, has been ongoing. And tragically, from what we gathered, this house that they're trying to renovate, this brother and sister, actually belonged to another brother that unfortunately deleted himself from the planet inside that house. So the whole thing is kind of sad and messy, to be sure. But let's go ahead and switch over to Judge Fleischer.
The curb as he enters the parking lot and finds a parking spot. The defendant then puts his car in park and sits for several minutes. The defendant then put the car in drive as two vehicles were passing, and he attempted to drive over the curb and through a ditch towards them. The defendant made several unsuccessful attempts to launch his car over the curb before he succeeded at 2:17 a.m. Another vehicle stopped and tried to help the defendant, but he was unsuccessful. A wrecker arrived at 2:37 a.m. and repositioned the vehicle on the roadway. The officers did not arrive on scene until 7:49 a.m. and the breath results were 0.066 and 0.065.
All right, Mr. Brown, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail.
Yes,
You
sir.
understand?
Yes, sir.
Can you look to see if he has any prior DWIs?
Yes, Judge.
He has a valid Texas
He
driver.
does have a valid driver's license and he has no criminal history.
All right, Mr. Brown, you are not allowed to drive unless you have valid liability insurance in your name, car insurance. I am also making that a condition of your bond. If you do not have car insurance, you're not allowed to drive. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer,
Can I
sir?
apply for a court appointed, please?
Sure. So I will give you an application. I need to know everything about you. I will take a look to see whether you qualify. If you do, we'll provide you a lawyer today. Deputy Miranda is going to give you an application. I'm going to have you now sign a reset with Victoria. Will, I guess, know Felicia today? Oh, she's floating elsewhere. We'll eventually have you meet with pretrial services to go over your bond conditions, and then I'll just have you take your seat in the jury box. Okay?
Okay.
Please.
That's it for now, Judge.
Any THAs?
No, Judge.
Okay, where's Marcos? You ready?
Yes, Judge.
And what am I signing?
I got two, Your Honor. First one is going to be Diego Gonzalez. Done the application, he's done the T-Res. And we have mitigation, we just need to turn it in.
It's 213 days old.
Right, well, let me see on this. And the reason why I asked, I have another one, that the new thing is that now they need mitigation. Like I have another one I'm about to talk to you about, Guevara, that it was defective light, 0.126. they're asking for mitigation.
It is below a 0.15.
They both are. So I'm not sure.
I get it, but I have here that you've been working since the beginning of February for
The
mitigation.
application was in, the TRAS is done. So theoretically, if it were the old rules, they'd both be approved and
I'll
we'd
give
have
you a week
contracts.
mitigation and then on this one.
But you understand my point, right,
I
Judge?
understand.
All I have is that it's pending approval right now.
And I was told that it was mitigation needs to be turned in
Okay.
on both. And the same thing happened to me in court 8 yesterday, Judge. I think across the board, they're saying that you need a mitigation regardless. That's what I've heard as of yesterday. That's what I heard as of yesterday.
So what's the difference between mitigation versus, I guess, just the application, right?
Yeah, and
Do we have like a bright line rule or?
I do not judge, and what I can do is, I'm still kind of learning the rules as well. My understanding was that we were still under the old rules, which was no mitigation. If you're going to fire guys and change.
All I know is both of my guys today,
But how do you know, Shatori?
I send the TRS reports to Brenda and then she tells me, that the clients need a mitigation package.
So could it be based on the results of the TRAS, whether they need a mitigation, you think?
I don't think so, because
I don't
one
think so.
recommended SOP and one was EDO, so.
Okay.
I talked to my supervisor last week about this. My concern for that meeting was that we would rules.
right? So on both these guys, we turned in the app and they got the TRAS done on 2/25. So in a perfect world, we would have had the contracts
Sure.
today.
Okay, so I mean, I'll give you a week on both and just try to get it in, and then,
One client of mine, I think we talked to him. Anyway, I'll get it done. I'll get it done. Okay, thank you, Judge.
sure, thanks.
Hey, real quick, since if you watch any Judge Fleischer, there's the constant mention of a TRAS. This from the Community Supervision and Corrections Department, Harris County, Texas website. The TRAS captures a broad range of criminogenic factors, including criminal history, employment, education, family, peers, neighborhood problems, substance abuse, and criminal attitude factors. During that assessment, if there are any indicators that the client may have an alcohol, drug, or mental health issue, the appropriate trailers will be conducted to assist in determining if further evaluation is necessary. It's just, this is something that's mentioned every day in Judge Fleischer's court, so I thought it worthwhile to actually get the official definition of what that thing is. Let's get back to his court.
Do you know?
Processing.
And then,
So I can sign it, please?
can you appoint someone to Weber, please?
Yep.
Because someone filed 2 affidavits on their behalf. And so,
2 affidavits?
Non-prosecution.
Oh,
Hunter,
Morning, Judge. I'm here on Holman.
okay,
So, Judge, his felony set the 18th. I know it's not out of the same incident, but this case would have never been charged but for that case. In that case, they haven't made an offer. They have had a rib call with CW, but in the facts, it's alleged that there's a video, and doesn't seem they produced that video. I would just ask for one more reset to see if there's even an offer made on that.
whoa. Are you telling me that there's a video and you haven't gotten it?
No. I'm talking about in the felony. There's a video that hasn't been produced yet, which would tend to show that CW isn't cooperating or isn't, doing what they need to do in that case. But I would like one more reset in this.
Is our case out of the same transaction as the ag?
It's not, Judge, but this case would have never been charged but for the ag.
1 second.
So, Your Honor, it looks like,
Are you familiar with this case?
yeah, I just took a look. So it looks like the warrant was issued for the ag. About it. when they were serving the warrant, the abatement. No.
Okay,
So that's,
I see.
they're not, same transaction, but they're.
The felony set for 318, do you want the day after?
Judge,
Or you want farther out?
I was hoping to get like 30 days.
Yeah, no problem. We'll give it to you.
Thank you, Judge.
Hold on. Let me get you a date. Hold on. Don't go anywhere.
What's the last name, Judge?
Bottom of page 14.
Go ahead and sign. How is April 15th through the 17th?
April 15th to the 17th.
The 16th works.
All right, it's yours.
Thank you, Judge.
Offer?
Yes, there's a time served offer.
Yeah.
Okay, thanks.
Okay. All right, Hunter. We'll see you soon.
Have a good one.
You too. Take care. Anna,
Can I approach, Judge?
please.
I'm approaching on Torrance, Torrence. She's on bond.
Okay.
Yes.
How's she doing?
Oh, she's doing well. We're just waiting on.
No issues?
No issues. I'm just approaching because it's like 180.
Yeah, it's up there. Do you have
Yeah.
an offer?
Can't do the math in my head. But we are still waiting on tops. And I've spoken with the state, and Chief is still waiting for it as well.
Judge Fleischer's court's a little quiet at the moment. Let's go ahead and see what's going on in Judge Simpson's court. He's doing a lot of hearings this morning, and he actually just came back from recess. So let's see what's going on.
Council will reset.
Case from HFSC.
How long does it take to even get a response?
Probable cause conference will be adjourned March 27th, 2025, 9 p.m. Bond continued.
Thank you, Judge.
Court calls the case of the people versus James Falcofor. Falcofor. Excuse me.
Good morning, Your Honor. Rachel, Assistant Prosecuting Attorney. I'm happy to-
Morning again, Your Honor. Christina Costantino, appearing on behalf of Mr. Backelpour. Mr. Backelpour, can you please state your name for the record?
James Backelpour.
Thank you. And Judge, may we very briefly approach? Please.
Yes.
Thank you.
Should I go?
Well, Judge is muted. Let me quickly say good morning to all of you. Nice to have you here for day 2 of the Courtroom Files live streams. Hopefully everything's going well for you this morning. Here in the Sonoran Desert, we had 4 drops of rain, which is almost like a thunderstorm or a torrential rain for us, so that was interesting. Hopefully things are going well where you are. Let's get back to court. Okay, well, may we briefly approach turned into not being so brief. Hopefully they come back to us soon. Do us a favor, if you're watching, put in the comments what kind of court interests you. We want to do things differently here than what everybody else is doing, which is one of the reasons why we're moving from courtroom to courtroom, is we want to not just cover one thing, which is what a lot of channels choose to do, and more power to them, but we want to bring something a little bit different. But let us know in the comments what type of things you like to see so we can work to bring them to you. And let's go back to Judge Fleischer. He's actually got things to say. Let's go there.
No harassing, threatening, or abusive contact with a Cynthia Montalongo and a Adelia Montalongo. You understand?
Sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, you are stuck with us until you either complete it successfully or it gets revoked. If you don't do your stuff on time, if you pick up a new case, if you get kicked out of a class, all these are causes that could be potentially revoke your probation. We issue a warrant for your arrest, put you in jail. You're looking at an entire year in jail if you violate this agreement. Do you understand?
Yes, sir.
Knowing all this, do you still want to do this? Knowing all these consequences, by entering into this agreement, you give up nearly every right known to man. So if you violate this, holy moly, you're looking at a ton of time. Do you understand?
Yes, sir.
All right. Can you get this done?
Yes, sir.
Okay. How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I will withhold it for 6 months, give you the opportunity to complete this thing, and I'll make you a deal. If you do well, if you get your stuff done quick, I'll take you off in half the time as a reward. But that means be nice to everybody. Don't be a problem. Don't test positive for anything. And just be nice. It's not hard. Do you understand?
Yes, sir.
The worst possible thing you could do is just take off. Because once that happens, you abscond, we issue an immediate warrant. If there's ever an issue, you can come back, talk to us, and we can always work things out. It's never about the money. I don't care about the money. I care about you doing the classes and you learn something so you don't come back. There's an affirmative finding of family violence on this thing. So that means you pick up another one, you could be looking at a ton of time. Do you understand?
Yes, sir.
You may not own a gun or ammunition as a result of this thing as well. Do you understand?
Yes, sir.
Okay. All right, buddy. Good luck.
Thank you, Your Honor.
Yeah.
Hi, Greg. Look at you in a tie and everything.
It's set for trial, but it's gonna reset ERD.
Okay?
I know, what, I don't dress well every
I'm
day? Is that what
kidding.
you're telling me?
Come on, man. I'm kidding.
Okay. I have, today, I have two cases in here. First one, Alicia Williams. She is present. I believe it was a BVR, but I think she had a more recent test and she should have been clean.
Come up, Miss Williams.
And just so you know, I have just been offered a PTI, which is a drug course, and they're dismiss it. So, just so the court is aware.
Judge, she did test again on the 3rd of March and it did come back negative.
That's good news. That's all we're asking. Don't use. That's all we're asking you to do. You've been given a great offer where if you complete a couple things, they're going to dismiss your case. It's not hard. Just get the things done. The quicker you do it, the quicker you're done with everything. Okay? You're going to get tested again. So be ready. Okay, don't test positive. Okay, good luck.
I'll talk to you about it. Just have a seat. And then I don't see,
Continue on.
Yes, Judge.
I don't see fugitive prosecutors.
Did you get a fugitive case?
No, this is a reset. I mean, he should have been picked up.
On?
Huh?
Is it on?
Pucci, Pouchie.
Is there a local that we're tracking?
Let me bring it up. Sorry.
There's no local, so
Not that I recall. Unless something.
to see when they waive, if they did.
I didn't get an email. I mean, do you want me to run across the street ERD and just come back and see if they're here?
Who?
Fugitive?
Oh, they're gonna be here. Well, let me text. Hey, do you have any dismissals on Pucci by chance? On Pucci? Yeah, on the jail docket, it's,
I'll check my email again, but I haven't seen anything. I'm usually pretty good about emailing me pretty early. Oh, there's Amy.
There's Amy. There you go. Maybe they'll file a dismissal here. I don't know. I don't know. You know, I didn't see it. Maybe it's on the bond doc. It's on the bond doc.
Okay.
Is he on bond, Greg?
I mean, February 20th, he kept the waiver.
What is that person's reply?
He waived extradition February 19th
Oh, yeah.
to Calcasieu Parish. He had 7 different charges. And reset date for pickup is 3/6, and he wants to keep the waiver was what happened. Those are my notes.
What's the word, Amy?
Let's switch over to Judge Shackelford. She's starting a hearing that might be of interest. Again, Judge Fleischer's court is just a little bit slow this morning, in our opinion. There's not as much intriguing going on. He's hot and cold, in our opinion. You can have like amazing things going on and then nothing. But that's why we do this live, where we switch between. So let's see what's going on over with Judge Shackelford.
I'm Natman. Miss Salvatore, can I get your appearance?
I'm sorry.
I'm sorry. Can you tell me your first and last name?
Deborah Salvatore.
All right. And then Mr. Natman?
John Natman.
All right. So we were here previously, and Mr. Natman, at that time, you had Mr. Constant representing you. And
Yes.
there was an agreement at that time regarding Miss Salvatore, the attorney fees she had paid, and trying to get the trust. There was a trust that she had originally retained you on. And Mr. Constant made assertions to this court, or representations to the court, that he would be handling that trust for her going forward.
Right, and Mr. Constant is still representing me. I don't know why he's not here at the moment. But my understanding is that that we're all set. I've been talking to Mr. Constant about this all along. There were some corrections that Miss Salvatore had about the trust that are still being done, and then it will be ready to sign.
All right, Miss Salvatore, tell me from your perspective what's going on.
Your Honor, it's been almost 2 years.
Oh, I am well aware. What can you tell me? Is the trust done? What Mr. Natman just made some representations that you're just waiting for some final modifications, or what's going on?
We received a copy of what Mr. Natman had. We made adjustments. However, we have never seen those copies.
How long ago did you make the adjustments?
Last year.
Okay, well then,
Like-
at this point,
Like,
I'd
one
like,
sec, Mr. Natman, wait. So like December of last year or like October? Like just Miss Salvador, can you just give me like an idea?
I'd say Christmas time, November, December.
Okay.
And it's, I mean, my husband's name isn't even right. So.
Oh, Mr. Constance here.
and I would like to wait for Mr. Constant to be here. Oh, there he
He's
is.
here right now. Mr. Constant? Good morning. Mr. Constant, can I get your appearance?
Robert Constant on behalf of the defendant, John Natman.
All right, so I have that I signed a judgment back on October 19th of 2023, awarding Miss Salvatore, there was a judgment awarding her the amount of $3,245. And Miss Salvatore, did you get that money back?
Yes, we did.
All right, so you got that amount of the money back. The $3,245 was paid. And
Yes.
then what was the additional amount that was outstanding?
$1,600 for the trust.
So here was the, not to interrupt anyone, but briefly, Your Honor, here was the settlement, as I understand it. This was originally a small claims removed. And the money the plaintiff paid Ms. Salvatore for work on a civil case, which she was able to hire another attorney and actually get a verdict. That money was refunded by the defendant. The remaining part of the settlement was that I was to prepare for her and her husband, her trust, her a pour-over will, revocable living trust, general durable power of attorney, and power of attorney for health care. And those documents were prepared. There's some corrections that need to be made to those, and I'm glad to make those. I emailed her and also sent her a text message, but that is the remaining work that has to be finished. And I also assisted her, very nice
But
lady.
look, Mr. Constant, we were here on November 30th of 2023. So that's a year and what? 1, 2, 3, a year and 3 months. So 15 months ago, there was an agreement that the trust would be completed by you on behalf of Mr. Natman for the additional money, or to basically satisfy the remainder of the $1,600. It's been 15 months. Like, these are not like, listen, I don't know what the extent of the trust was, but doing some, a lot of these forms, these are not complicated forms. And it's been 15 months. Like, how long is Miss Salvatore supposed to wait? This goes back to June of 2023, and her original contract with Mr. Natman goes back to 5/14 of 22.
Those were all done and signed, Your Honor. Basically there's one correction that needs to be made, but they were done and signed. She spends her winters in Florida, and so the corrections have been made, and the corrected documents will be signed whenever she's back in town. But the documents were all done and signed. The will, the pour-over will, revocable living trust, power of attorney, and power of attorney for health care.
Ms. Salvatore?
Not to interrupt, but we were told to sign and then corrections would be made.
And that was back in December.
No, this is before we left for Florida. We went to
Which
Mr.
would have been
office we went to Mr. Constant's office. And let me please, first and foremost, this was not his responsibility. And we did appreciate him trying to take forth this, over for Mr. Knappman. We don't expect him to complete it. This was not something that we held against him. He tried. I understand he's very busy. However, with that being said, we did sign something, but there had to been many corrections. And I'm just, I didn't want to have to wait because we travel. And there were so many corrections. If, God forbid, something happened to us during that travel time to get back to Michigan, we have nothing.
Right, that's concerning. And it's been a year and 3 months since I saw you that these documents were being worked on.
And that's 3 trips already.
Well, Your Honor, if I may, so the plan was that the documents have been corrected to sign them when the next time the plaintiff and her husband are back in town. And I'll be glad to put on the record that that will be done, that needs to be done.
Was she sick of waiting?
Exactly.
Well, we can sign them whenever she wants. She just has to, she's in Florida for the winter, as I understand it. So the wills, powers of attorney, they were all signed, bought different materials to bind them. And one of the heirs, one of the personal representatives were mixed up between husband and wife. But other than that, everything's been done. So we can set a time and we'll get those documents signed, and that'll be the the extent of it. And I'm glad to do it. I did send her an email and also some text messages. Let's arrange a date to get it signed.
Wisconsin.
Sorry.
Southport.
I'm sorry.
No, go ahead.
I said that was a couple hours before court. That was last night. I've been calling and asking, and I understand he's extremely busy.
I know, but you paid for services. I mean, listen, if attorneys are extremely busy, they don't take the work, right? And I mean, I just can't, she signed, I mean this with all due respect, Mr. Constant, I've known you for a very long time. Mr. Knappman, I've known you for a very long time. But Miss Salvatore is just a normal person. She hired an attorney in May of 2022 to do these documents for her, right? That was part of the original money that you gave him. Am I correct on that, ma'am?
Yes, exactly.
And it is now we're 2 months away from it being 3 years. And she still has not done, and I understand there's some travel, sometimes documents take a little while, but like that is such an excessive amount of time for a client to wait for documents, for her to wait for these, that is completely unacceptable.
Your Honor, we did sign those papers in the office. He was generous enough to have us come to the office and sign them. And then when I got to Florida, I received a file. So I went to the local library and printed everything off, $40 worth of print. And in those documents, I had, we went through it all and we're like, oh my gosh, your power of attorney is my niece. My niece is your daughter's my power of attorney. Everything was mixed. And that's when we said, we need this sorted out and corrected before we could even move forward. And when
was that approximately? So you were already in Florida then. When was that?
2023.
With
Well-
who? Mr. Constant or Mr. Knapp?
Mr. Constant. We received
Okay.
Mr. Knappman's paperwork.
Yeah, I believe that was 2024 when we signed everything. And
No.
it's just a question of scheduling. Certain persons are reversed, and there's that one correction that's been made. And next time we can schedule a time, and now if the plaintiff wants to, or by a certain date, and sign the corrected documents.
But that would be after another trip home in June. Whereas I could go here and get a will done or a trust done to protect us. It's been a rough year.
Well, I can email you and I think I already have the corrected documents with that change made, and then you can.
We have.
In fact, I can mail you the printed documents to save you the money from having to, and you can get them signed down there. And then when you're back in Michigan, or when you come back to Michigan, you can sign the original documents at my office, and we'll get them notarized.
I mean, that still puts Miss Salvatore out another several months without documents that she was, I mean.
Well, everything was signed, and then after she signed them and left, and she was involved in the civil case that I was trying to help her out on. She discovered the parties are reversed, and the corrections have to be made, and the corrected documents have to be signed. So I'm glad to mail her the documents with the corrections, and then she can sign them and have them signed down there. And then next time she's in Michigan, or when she's back in Michigan, which will be June.
Yes.
We'll, by a certain date, sign the corrected documents at my office.
I'm just gonna, you know what? I can't do that, Mr. Constant, in good faith. Like, Miss Salvatore's been more than patient. I'm awarding her the $1,600. And she can retain whoever she wants to do it. But she's entitled to that. She's been more than patient. And it's unfair for her to have to wait any longer. I mean, this is something from 2022. And I know that everybody knows that this has just gone on way too long. I mean, I'm signing an order for her to have that $1,600 returned to her, which should have been the remainder of the judgment that was due and owing to her back last time we were here in October or November of 2023. November 30th of 2023. I mean, she's entitled to it. It's been too long.
Well, and then, if I may, Your Honor, so what's to be done, if anything, with all the documents that have been done and prepared?
You could bet. I mean, they need to be, she's got to get a bunch of it redone anyway. I mean, Mr. Constant, you and Mr. Knappman both know this is unacceptable. I mean, I don't know what to tell you. She should not be she's been waiting since 2022 for a trust, 2022 for a will. And I understand some of the paperwork's been done, but she's still not got what she paid for. And I'm not going to make her wait any longer. I'm just not. I understand.
Well, let me suggest this. What we might do is, I will mail her by a certain date the documents with the corrections. If that's not done, then judgment to be entered for the $1,600 to be paid by the defendant. If she wants to do that, because a lot of progress has been made, everything's been done. It's just the
Your Honor,
parties are reversed.
Let him finish.
The only thing
Okay.
I would like, Your Honor, the
Yes,
only thing I would like to say is that Mr. Constant is a very reputable person. I trusted
Yes.
him. I did try many times before Christmas this year to try to get the trust. I did talk to him. He did explain to me that during Christmas, he would have a break and he'd get it done. And then I never heard back again. So I'm afraid because of his work schedule, and I understand he's busy. First and foremost, he's a very busy person. I appreciate his offer, but I was promised many times. I don't think it's going to happen.
well, Miss Salvatore, I'm leaving it up to you. I can order Mr. Constant to overnight that package to you for you to sign everything you need to sign. He can overnight it today. You'll get it tomorrow, presumably, and enter all the signatures. Now, Mr. Constant, if you send her original copies overnight and she signs them and has them notarized in Florida, are they binding?
Yes, if they're signed and notarized by her and her husband, they're binding. And then I've got, like I said, a regular binder and all the tabs and everything that I bought at Staples. So there were documents signed. There are corrections to be made to those documents. But yes, to answer the court's question, if they're signed and notarized down there in Florida, they're binding. They can even be notarized electronically here in Michigan. I will mention this quickly. In Florida, any estate work, it's very expensive. I mean,
that's a Miss Salvatore problem, but you might get it done promptly. I mean, I'll be honest with you. I'd rather pay $2,500 and get it done quick than pay $1,600 and wait 3 years. I mean, I'd rather pay $5,000 and get it done quick than wait 3 years. So look, she's waited long enough. She doesn't seem to be interested in that agreement. She's $1,600 for the plaintiff to be paid within 30 days.
Thank you, Your Honor.
All right, we're all set. Thank you.
Thank you, Your Honor.
Okay, let's go ahead and switch back to Judge Fleischer's court now and see what's going on there. Again, it's been a little quiet there this morning, but it looks like he's got somebody in front of him.
And one for us. I don't have any arguments, Judge.
No, Mr. Guerrero, please. Yeah. Lupe. I don't even know what happened, so let's figure it out. I mean, all I know is that this is a third VP.
Correct.
You know?
Correct. The state has made an offer. He wants to think about it. If we can get a reset until after his felony court date, which is next month, I believe, April 23rd. And then on our next setting, he'll let us know.
What did you offer?
I'm Sebastian.
Or is this?
Yeah, Sebastian offered a tentative offer of maybe 90 days. He didn't put it in yet, though.
Okay. It'd be interesting to see. Is there an offer upstairs too? Do you know?
Let me check.
I mean, it's a new case. It's like,
It's brand new.
I can't imagine there is. It was filed,
Mhm.
5 days ago. So
Yeah.
No offer on the cases upstairs.
I mean, theoretically, we could have a hearing to hold him at no bond.
I leave it to the court. He has no bond upstairs. Regardless, he's going to be here.
Let's see when they set. You need translating?
No, he speaks good.
Good morning, Mr. Guerrero. With us, you have picked up a terroristic threat in January of this year. A month later, you pick up a violation of protective order. It's now come to my attention that you've picked up yet another violation of protective order. I have no idea what happened in that new case. We're going to find out. You have the right to remain silent. Anything you say can and will be used against you. The felony.
The felony? Okay, yes, Judge. On February 28th, 2025, an officer was dispatched to a suspicious persons call at a residence in Harris County, Texas. On scene, the officer observed the defendant across the street from the complainant's house. The complainant advised that she made multiple reports on the defendant, and on January 28th, 2025, the defendant was ordered not to go within 200 feet of the complainant's residence as a part of a MOA. The defendant was at her residence on February 27th, 2025, and stayed about 20 minutes and knocked on a window. On February 28th, 2025, the defendant returned and the complainant observed the defendant sitting on her porch.
So the newest one is from the 28th, just gets filed in March.
Yes.
Yeah.
Do we know if any threats or anything like that happened?
No threats are alleged. We've made 2 attempts to reach out to the complainant since the incident, and she hasn't answered yet.
Okay. We have court orders for a reason, you know? We don't like to just put people in jail willy-nilly for shies and giggles. And I get that you have nowhere else to go, but a court order is a court order. You know, if you ever have any issues, come back, talk to us. Perhaps we can work something out, but you just can't do stuff on your own. It's not the worst, right? So what I'll do is I'm just going to raise the terrorist threat by $1. Okay. I'm not going to give you a bond reduction yet on the new case. So I've on the VPO, the violation case that you have with us, the bond is set at 25,000. On the terroristic threat, your bond is set at 2,500. You have a PR bond on that case. I'm going to yank the PR bond because we can't just continue to do this. I'm only going to raise it up by $1, but I don't know if you're going to get out, but how do we get your attention, Mr. Guerrero? You know, what do we do? No means no. So I am now going to place a leg monitor on you. If you get released, I'm putting a monitor on you and I'm giving you 1,000 feet radius that you're not to go where she lives or where she works. Do you understand?
Yes, sir.
I don't know if you're going to get out because you're being held at no bond on felony case, but if you do, just don't go back. That's all we're asking you to do. Okay, so
We're gonna get a reset into after the felony so he can think about the offer and see what's happening there and then.
okay, so the felony's set for
April
April 23rd. Do you want to do the day after?
Yeah.
Okay.
The day after.
I'm sorry, but you know, we just come back. We can find you a place to stay, Mr. Guerrero. Doesn't have to be like this. You know, really. All right. Good luck, friend. So I need him to sign conditions so
Okay.
before he takes off.
Okay.
So
I'll need them later.
So Felicia, so GPS prior to release, no weapons, no going within 1,000 feet of lives, works, and then prior to release.
Yes, Judge.
And then, so 2501
Yeah.
Please. on the terroristic threat, Guerrero. Jesse, hey, how are you?
I'm doing fine, thanks. Hernandez Quinteros is on your docket today. Spoke with the DA earlier and they just completed the RIP and was just released and I don't have it yet.
Okay, we'll give you a couple weeks. It's old. It's old. So at the next setting, if you want PTI, please have everything ready. It looks like mitigation on everything now.
Paperwork should be okay.
Sure, but just be ready. Accurate. Okay, if you want to. Okay, take care.
Judge, and we're revoking and raising, on both of the Guerrero pieces or just the terrace?
Terrace by $1. Okay, machine. Hey.
I'm approaching on Kevin Caesar.
Okay.
And he has accepted the clean and green program and we.
Is this what we talked about then?
Yes. And so we paid the fee, submitted the contract and signed up for the earliest date, February 7th.
Did they get a hold of him for the thing?
So I emailed the prosecutor. He said someone called him, but he didn't know who. And he said, are you willing to do it early? He said, yes. So then I was like, did they call you back? Because they said they were calling back. No. So I emailed the prosecutor assigned to the case and said, this is what happened. We're willing to do it early. Can we do it? And she said, I can't help you. Go log in. And I logged in and the earliest date was May 28th. And we already have April 30th.
Okay, so just keep it, just,
I'm
we'll
trying
set,
to get it done, but
don't worry about it. It's not a big deal. We'll set you, I guess, a couple
May
days
1st or
after.
2nd or something. Yeah, okay.
Okay, thanks.
Thank you.
I was gonna approach on a plea for Kevin Halbert.
I'm ready to do this. Mr. Halbert, are you ready?
She told me it's open to you. I have no idea.
Oh.
Oh, I'm sorry.
On Halbert?
Yes. I apologize.
You're talking about someone else?
else.
You're doing good. Don't worry about it. So he's going in now?
Yes.
Okay. Good morning, Mr. Halbert. Mr. Halbert, you're charged with assault and bodily injury. You're facing a year in jail and or a $4,000 fine.
So sure he said it was a trial. Okay, fire the paper. Oh.
All right, so Mr. Halbert, you're charged with assault bodily injury. You're facing a year in jail and or a $4,000 fine. You have worked out an agreement. They're offering you 135 days in jail with credit for the 35 days that you've done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accuser. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record. It's going to be there forever. From now on, you're facing a minimum of 90 days in jail. Do you understand? You still want to do this? How do you plead to the assault? Guilty or not guilty? I'll find you guilty, sentence you to the agreement, and we'll take you into custody now to serve your sentence. Good luck to you, sir. Thanks. So, Deputy Miranda, we need to take him into custody now. He's going in. Do you need him still? Yeah, he's got time. He's doing right.
You're gonna do 10 days.
Yeah.
So my co-host Ellie has entered the studio now, so if you see a cat wandering around, it's her. She is almost a year old, be a year old next month, and she's full of spunk. Yeah, do you want to come say hi? Come here. Come here. All right, say hi, Ellie. Hi. Mao? Yeah. Play with the microphone. All right. You can sit with me if you want. It's up to you. But you can't get on the Legos behind me. There are rules.
Was your case, right?
Oh, yes.
Sir.
So they got a hold of mom yesterday, remember?
Oh, yeah, sorry.
She was in the hospital.
Yes, I talked to her yesterday.
Just so you know.
She was okay with him returning to the
Freya.
home. Obviously, it doesn't want.
Harmful, injurious contact.
Yeah, no assaulting, no threatening her.
She's here.
So, should be good. We can talk a little bit more about it later,
Hey.
but she just wants like anger ban.
Freya.
Hi, Judge. We're here on Nathan Porter, an off docket.
Yes, Judge, the manager said she was asking for an extension, so I'm waiting.
Did you hear that?
I couldn't hear it. I just heard request.
So she said that she needs an extension. And she's now entering in a pre-signed waiver. So it sounds like to me they need more than 3 days. Right, Amy?
Yes, Judge.
Oh, so he does have a pre-signed waiver?
Let me look, let me make sure. But it's still got to be within the 30 days, so.
Council for reset.
Wow. Hey, Shreya.
Yes, Judge.
Let me read this to you.
Okay.
So these are some of the conditions that you agreed to for supervised probation in Arizona. I will report any contact I have with law enforcement to the APD within 72 hours. I will submit to a search and seizure of person and property by the APD without a search warrant.
Arizona's not messing around, Judge.
I'll tell you what.
Real quick, this
I don't see
exchange is
where is it, the pre-signed waiver?
Oh, it was on that.
it's only
first page.
interesting to me because we live in Arizona and we know that it's tough here, but there's a guy in Texas complaining about how tough Arizona is. You'd expect Texas to be the tough place.
There's a fourth page. Do you have that one on?
This one?
Yes.
Oh, I see it.
Okay.
I see it. Okay, I missed it. So it says here, I acknowledge receipt of the conditions of my probation and any attachments added. I understand that by not abiding by the conditions of my probation can be revoked and the court may sentence me in accordance with the law. In addition, I waive extradition for any probation revocation proceedings in this matter.
Okay. So when do you want to reset it, Amy?
So the 30 days would be reset to 4.
Okay.
Here, let me give this to you because we don't need that. And then I'll enter it. Here we go. Have you spoken to him yet? Is he here?
No, he's not here. I spoke to him 3 days ago. I've got contact information for him though. Well, like a family member.
Do you want to put him on the docket for tomorrow so you can explain it to him? So he knows?
Yes, especially since it's a lengthier reset. I'll let his family
You
know,
can
but
put
if
him
we
on for
could,
tomorrow so that she can at least contact with him and let him know what's going on. Okay.
that'd be great. Thank you so much, Judge.
And then that way, and then after tomorrow, you can set him for that, whatever the date is that year. Okay. Shrey, anything else?
Nope, that's it. See you tomorrow, Judge.
Okay, see you.
Hey, Judge.
Thanks, E. Ms. Teachy.
Good morning, Judge.
Hi.
I'm here on Miss Malveaux, Deja Malveaux, the mother with the son. Her appearance was waived today, and we got a short reset for the state to get in touch with the son, and I believe that they have.
Yes, we have heard from the son. He said that he is okay with amending the bond conditions. He is okay with allowing her to come to his games and is okay with her, with communicating with her over the phone. But he said he's already doing both of those things. But he made it
But
clear
she's
that
not supposed to have contact with her. I mean, what the hell? Why do we have court orders if no one's going to follow it? Really? I mean, we're supposed to know about these things and we take action on it. You can't just do whatever the hell you want to do, which is what's going on.
Judge, it's an allegation that has not been presented for me to
But a
defend.
court order is a court order.
An
You know,
allegation of a violation of a court order that needs to be, I need to be noticed so I can defend it. I can't
I
defend it
get
on
it.
the
Well, that's
fly
what I'm
today.
saying, you know? If there's a violation, you got to let us know so we can take appropriate action,
yeah, Judge.
you know?
That she is in the process of doing the PTI work to get the case dismissed. And
It doesn't make me feel better that she's still violating court orders, you know?
I know, but I tell you that to argue the point that this case is probably going to be disposed pretty quickly anyway.
I understand.
So we would just,
So you need to let me know when these issues come up so we can take appropriate action, you know? I mean, how are we really supposed to let her go to the basketball games and this, and she's not gonna have contact with him? I find that hard to believe that's gonna happen because she's still having contact with him now.
Well, Judge, last time you said that you would not be amenable to that, and I have explained that to her.
But she's still having contact with him now.
I can't control that, and I don't have any allegations in front of me to respond to that. I hear the court loud and clear on that. But I did relay last time that the court was not amenable to the contact at the games because she was here and that she heard everything. And so we were just coming back to see if she could at least amend it for the phone and have, so if she is in violation, which I'm not admitting she is, she would no longer be in violation on that, in that regard. And then hopefully she'll get this PTI done by the end of the week, and this is the last you'll hear of me on this.
Setting this case for Monday. She must be here Monday if she's not done with it. And then I'm gonna take,
Hold on just a second, please. What day am I in? Monday is, I don't even know what day I'm in right now, Judge, sorry. It's been a long week.
day next week, Ms. Teachy.
Anything
but Friday.
The 12th would be the easiest for me to make sure that I can be here, judges, that, because I have
That's okay.
appointments in the 8, in
Okay.
court 8, and I can just pop over here with her.
I'm okay with that.
3/8, and she's got to be here and she has to be finished with the PTI?
Or I'm setting a case for trial. And then we'll respond to the, you know, allegations. But I'm not happy with her, you know, I'm not gonna acquiesce. She's doing whatever she wants to do. You need to reach out to her now that if she continues, then I'm gonna take appropriate action. I'm not gonna agree to this now. I mean, she has a week left. Let her do what she needs to do, but she's continuing to do what she wants to do anyways. And please reach out and let her know that or let him know that no means no.
Yes, Judge.
Okay.
All right, Judge, I will
Thanks.
tell her that the court was put on notice of the violations and is now either get it dismissed or
We'll
we're
have it
gonna go to trial. That's kind of hard on me though, Judge, because I was just appointed, but I'm being punished for it, but can we address that on?
Set it for trial if she's not done by Wednesday then.
Okay, thank you so much.
All right. Ms. Strong.
We have Elio Jose Guerrero.
Hold on a second. Real quick. I have it to Ben. You ready?
Yes, sir.
Good morning, Mr. Glover. Got it. Okay, so Mr. Glover, you have picked up a burglary of a motor vehicle. You've also picked up an assault of a family member. On both of those cases, you're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 120 days in jail with credit for the 66 on the assault and 68 days on the burglary of a motor vehicle. You need to understand that both of these cases will go on your record. They will be there for the rest of your life. On the assault case, there's an affirmative finding of family violence, meaning you pick up another one of these, you will be facing a 3rd-degree felony, 2 to 10 of the penitentiary. And if you've been to the pen, it could be just, they can continue to enhance your punishment, perhaps 5 to life, 15 to life. Do you understand?
Yes, sir.
On the burglary of a motor vehicle, that is also an enhanceable offense, meaning you continue to pick up those cases. At some point, they'll hit you with a felony on that as well. Do you understand?
Sir.
From now on, you're facing a minimum of 90 days in any misdemeanor court here in the state of Texas. Any misdemeanor you pick up, it's a minimum of 90 days in jail. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, there's no turning around. This is stuck. It'll be there forever. Is this what you want to do?
Sir.
You also need to understand that if you're on parole, pleading guilty to both of these cases, they may revoke your parole, sending you back to prison. What is ISF? I don't know what's going to happen, but they can revoke your parole, send you back to prison. Do you understand?
Yes, sir.
You still want to do all this? How do you plead to the assault and the burglary of a motor vehicle, guilty or not guilty? I'm going to find you guilty. I will sentence you to both cases. I'm going to roll your court costs so you won't owe anything. Good luck to you, Mr. Glover. Thanks, Will.
Thanks, Judge.
All right, Ms. Strong, I'm sorry.
Okay, so we have Jose Guerrero. This is an old case. It's from 2020.
You have another Guerrero?
Yes, I do.
Okay.
So it's an old case. It's from 2023. The state wanted a 30-day reset to look over the case to see.
There's a 2B warrant, Judge.
Okay. Is discovery complete on the case?
It says the 911 call is still in progress. It was requested on the 14th, but I mean, if it's from 2023, I don't know if they would still have records of 911.
Yeah, I think they keep them,
Oh wait, no, that's on the felony. I apologize. Yes, discovery is completed. Besides, we need to subpoena for the medical records.
do you have an offer in the case?
No offer yet because this case just came onto my docket, so I'm trying to reach out to the complainant to see if I can get in contact with him first before I make any offer.
Okay. So he's really just, it's been in,
Yes, the first setting on this case was on January 13th, 2025.
yeah, so they filed it to be December of 23. And looks like he didn't get picked up until, January of this year. So we'll just give you like a normal, just, right. So it's like, how long you been on it? Did you just get appointed?
Yes, well, I've been on since the January
Do like
setting.
settings. I mean, you don't have to just have 30 days. Well, normal because it's been in just the 2 weeks.
Okay. Thank you, Judge.
Okay.
Can I approach?
Yeah.
Judge, I'm approaching on an off docket. If I can just give you the cause number 1 second. Let's see, Judge. So Judge, are you ready for the cause number?
Yeah.
It's a 2526711. It's a Nicholas Marina Odiambo.
Okay.
And Judge, I just want to get ahead of this. He has a bond violation report that I think is, if it hasn't been filed yet, it'll be filed soon.
I see it.
Okay, Judge, he missed a drug test.
Do you hear now?
Judge, he went to Arizona. His mother's in the hospital. She's diabetic and she has a lot of health problems and she broke her ankle. And so he went to Arizona kind of as a family emergency to take care of her.
Let's do this. I'm going to give him a week to go to a Quest diagnostic.
Okay.
and get it to us. If he doesn't, then I'm gonna revoke his bond.
Yes, Judge, for that, I will have to make an amended order for him. I can't do anything right now. He's actually been on the computer for like the last 30 minutes because everything is broken. But as soon as I can, I think
Okay.
to it.
So he has a week to go to Quest and get the result to us. If he
Yes,
doesn't get
Judge.
it done, then
He said that he could be back by about April 9th. He's just been taking care of his,
I get, but
but
he's
you want,
called,
within the next week,
it's supposed to, right. So
have him
he's
go to Quest
let everybody
Diagnostics.
know, so you know what I mean?
Is there
You
a
can't just-
particular drug panel you want him to get, or is there a comprehensive
You
one?
can get that information from pretrial services.
Okay.
Just tell him to
Hey,
call.
but it has to be Quest,
Quest Diagnostics,
like
okay.
not Punka City drug testing.
Right.
Right,
Okay.
okay.
He just has to call.
Thank you, Judge.
Abel's on.
I always tell him to call pretrial
Oh, you got it? Okay.
So-
I have to give this to the state so they can see it too. I just wanted to, so if you want to make a copy,
Yeah, let me look at it.
and then,
Is
is that your case? Abel, what's the cause number?
It's 255-4344. It's two cases, Judge. And it's, yeah, it's two cases.
Sebastian, is that, did you get it?
255.
4344. There's two cases. Thank you.
Ms. Williams, Raquel. I think she may be the last person.
Okay.
The last time we were here, you asked me to submit information for PTI. We were supposed to get that together. I have not done that. It's on me, not her. She submitted it to me.
We've been working on it since January. We're now in March.
She did, she sent me the information. It just was pieced together and I've been out. I haven't been well, so I just need some time to
So we can give you a week.
together. That's fine,
Is
Judge.
that enough to get it in?
You will give me a-
Okay. Yes, ma'am. Okay. Yes, ma'am.
Ready?
Hey, bottom on page 29, 1 week, please. Is that enough, Miss Moore?
I'm actually going to add for it to be Monday or another day that I'm here, so I can get it.
A week is enough
That's fine.
What did you say, Judge? I didn't hear. To do
to
what?
submit the mitigation packet.
Oh, more time for the.
Mr. D.
Yes, sir, Your Honor. Judge, we're approaching on Mr. Joshua Connor. The last we were here, I'd informed the court and the chief that I was having problems downloading the last time we were here, we didn't have the videos. And you had given us to the day to get that video. The chief has provided me a video, but it will not download. The chief is thinking about just getting me a USB to look at. But he has the video. I've looked at it on his site, so I know it's there.
Okay.
That's been shared before, I think it should be for the issue.
When do you think you can get it to him?
If I can run downstairs and get a USB, I can do it today.
Okay, let's see. Can you just get a bit of time and he can get it to you today and then we'll give you like a week?
Yes, sir. Yes,
I'm
sir.
pretty short staffed today, so.
Take your time. I'm here.
Go to it.
Okay, take your time. I'm ready.
Back on Jose Guerrero, do you have any other bond conditions aside from the ones from the magistrate?
Is this the one that we revoked?
No, that was Guadalupe Guerrero. What Jose Guerrero, we were just talking about it. That was the 2B.
He's in jail?
No, he's here.
Come up, Jose Guerrero. So he has a felony assault from January
Yes.
and then our assault here. Let's do PC because I don't remember anything.
Okay.
Morning, on.
Mr. Guerrero, you are charged with assault causing bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On June 14th, 2023, an officer was dispatched to a residence in reference to an assault call for service. The complainant entered into a storefront to make the report. The officer identifies the complainant by his Honduras identification card. The complainant stated that he and his family were at their residence in Houston, Harris County, Texas on June 10th, 2023. And he stated that some friends later identified as the defendant came over to the residence to discuss the complainant working at their residence located in Cleveland, Texas. The complainant described the defendant to be in his mid-20s to early 30s, and they were all sitting around. Miss Bougon asked the complainant if they could drink while they ate. The complainant did not have any issues saying yes to the request. Then Miss Bougon then asked the complainant if he could play music while they ate, drank beer, and talked. The complainant stated that while he was looking down at his phone attempting to start playing music, the complainant's son, Jose, struck him in the face with his left side, causing it to be swollen. The complainant stated he believed it was a close fist punch, but was not sure due to him looking at the ground at his phone. After the defendant struck the complainant, all three parties left the premises. The complainant stated that after the altercation on June 11, 2023, he felt pain and discomfort in his mouth and thought it was a broken tooth, but the pain got increasingly worse, where he felt like he needed to go to the emergency room. The complainant went to the hospital at a later date and then called officers on 213.
Okay, so what happened in the phony case then, please?
Yes, so on January 12, 2025, an officer met with the complainant who stated her boyfriend began going through her phone and accused her of cheating. The defendant grabbed the complainant by her arms and squeezed them, causing pain. The defendant then punched her in the face and threw her to the floor. The defendant then stomped on the complainant's head several times, causing pain and for her to bleed from both ears.
Mr. Guerrero, I'm going to find that there's sufficient probable cause to go forward with your case. I'm going to do everything in my power to protect every person of Harris County. Do you understand? If I find that you become a danger in any way whatsoever, I'm going to make your bond so high you're going to have teeth falling out. Do you understand?
Understand.
You are not to consume alcohol, illegal drugs, unprescribed controlled medication, and I'm going to test you like crazy. In fact, I'm going to send you for a drug test right now. Do you understand? If I find that you're using, it's really not going to go well for you. You're not to have any contact with the complaining witness in this case, not to go where they live, where they work, anywhere. Can you run his license, see if he has a valid Texas driver license? So,
It says that, oh wait. It says, the CDL is
Cortez?
unlicensed.
if you do not have a Texas driver license and or liability insurance in your name, you are also not allowed to drive. Do you understand? Okay, so I'm sending him for a drug test now. If you fail to go test, if you fail to come back, a warrant for your arrest will issue. Take the test, you must come back. Okay, take a seat for me.
Council for reset.
Judge, fortune on Mr. Weber, let me hand this back to you.
State, did you see this? Okay, I'm in, can I?
Yeah.
Okay, so can I file that?
Council
I
for
have seen
reset.
these filed in deeds before, so I would imagine.
Confidential, confidential. There's a.
Can you mark it confidential?
Yeah. I'll put it in seal, I'll put it in seal.
Okay, that's it, seal it. Okay, because I don't, yeah,
Yeah, that probably shouldn't be.
good
public.
idea. Okay,
Judge, put you for PC on this one.
well, hold on a second, I don't even have him.
Exactly, that's my problem. He's in custody and needlessly without probable cause being heard. I was told that that was the reason I was appointed to him this
No,
morning.
no, no,
that
so
he
I
could-
pointed you because we had gotten those two letters I didn't want to just file it, and I wanted to take the appropriate action when we got, because we got those two letters. I don't know who sent it. All I know is that we got it, and I wanted someone, that's why I pointed you to see it. I don't know anything about probable cause. I just know that we don't have him here today because I
Right.
guess he's still in processing.
Correct. So you will not entertain hearing probable cause without him.
I guess let's do it. Did the magistrate already hear probable cause? I mean, it looks like a magistrate already found probable cause. You don't think there's PC?
No, Judge.
Okay.
All right, March 4th, 2025, in Harris County, Texas. Officers were dispatched from assault in home. Officer met with the complaining witness, who stated that the defendant is her boyfriend of 3 years. Complaining witness stated that they got into an argument over where to eat. The complainant and defendant both denied that an assault occurred. Officer then spoke with the witness, who stated that she observed the complainant in her vehicle. The defendant opened the front passenger door and punched the complainant 5 times with a closed fist. The witness stated that she then observed the complainant and the defendant get out of the vehicle, and the defendant punching the complainant several times with a closed fist.
Wait. Okay, so initially, the defendant allegedly punches 5 times, you said? Or the witness? Or
The witness observed the defendant punch
okay.
5 times. The witness stated that she then observed the complainant and the defendant get out of the vehicle, and the defendant punched the complainant several times with a closed fist. Officer then spoke with.
I mean, Abel.
Judge.
There's no PC?
The CW says that no assault or terroristic threat happened.
Okay, there were
To the officers. It's based on her feeling pain, and if she's saying nothing happened, Judge. If she's saying that she wasn't threatened, she wasn't threatened.
Well, no.
Whether 20 people or 100 people see it.
Well, bodily injury can be inferred. You don't need somebody to say pain. You can infer bodily injury from conduct.
So what about the terrorist threat?
So the complainant at the end, the witness stated that the defendant stated to the complainant, quote, "I'm gonna fuck you up."
Again, if she doesn't take it as a threat, it's not a threat, Judge. We might think it is. And we can infer all we want, but that's not.
I'll refer that one to the court.
Say, okay, so it was at the time that the alleged assault is occurring? He says, "I'm gonna fuck you up." And he allegedly follows through. I mean, I think there's enough for probable cause, it's such a low standard,
Well,
I don't agree. Let's agree to disagree.
Oh, sure, and we can, right? But we have someone who's punched her 8 times in the head. You're telling me that's not gonna?
Well, I mean, sometimes that behavior is not that it's defensible, but it is permitted under the law, whether it's self-defense. I don't know, Judge. I don't know the whole facts of the case. I just have what the initial summary of the report is.
I think that there's enough PC to start to go forward.
I'd ask that you grant him, based on what the CW wants that the case be dismissed and what she's saying from the get-go, that you grant him PR bonds on these 2 cases.
I'm gonna be opposed, Judge. I don't think that the conduct here warrants any sort of PR bond. I think it's concerning that, there's a complainant who is adamant that nothing occurred, and the 3 independent witnesses are saying that she got assaulted. Pretty consistent with each other.
So let me read this to you. Because there's more. It says, motions for bond conditions, MOAP. Defendant assaulted and made a terroristic threat against the complaining witness, yada, yada, yada. Complaining witness denied same. However, there are numerous witnesses who heard the threats and saw the assault. Witness Kirby saw defendant swing at complaining witness 3 to 4 times and assault complaining witness. Witness Grantham saw defendant open passenger door to the car, punch complaining witness 5 times with a fist. Then complaining witness got out of the vehicle and defendant punched her 4 times in the stomach and in the shoulder. Complaining witness Sitpak saw defendant punch complaining witness 5 to 6 times with fists in the vehicle, 3 to 4 times more when she got out. I think there's enough problems. And I'm not ready yet. He's in processing now. We'll get him, because the problem is if I grant a PR bond now, he's going to be out and I can't put conditions on. And I'd like to put conditions on and, you know, we can talk about it when we get them, about a PR bond and stuff. Okay? The magistrate set bond on both of the cases. I'll keep it for now and then we can talk about it tomorrow.
Yes, sir. I also have Mr. Cortez,
Okay?
would request a PR bond. Don't shoot the messenger on this one.
I will never, I'm never going to begrudge you for, you know, zealously advocating, you know, really. Let me bring him out here. Let me talk to them. Do you mind bringing Cortez out real quick, please? Are you ready? Let me talk to, while they're bringing out. Let me talk. Okay.
I've got an off docket matter.
Okay. What you call it?
It is 2553123.
Okay.
Mr. Haygood.
Yes.
And he's here, and we're asking for a walkthrough. And they've spoken with the complainant.
Let's, hey, good, come up, please. Mr. Burns, are you hearing this too? Oh, you have, you have. You are Mr. Haygood.
Sir.
Mr. Haygood, you are charged with violation of a bond condition or protective order. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay, Sebastian.
All right, on February 24th, 2025, officer was dispatched in reference to a possible violation of protective order and made contact with Patty first. Stated that her ex attempted to contact her via Fortnite on an Xbox game system.
That's my jam. Fortnite? Oh, yeah. That's my jam.
He stated that she received messages under a username, OBT Haygood and LLUVVMEE. Message she received stated saying, "Hey, you, I miss your voice," and then received several friend requests. And she knew that the complainant witness stated that from prior experience, that was linked to the defendant's.
So he's trying to contact you through Fortnite.
Right, through the messaging system at the Xbox.
Right. Okay. All right. Mr. Haygood, I'm going to find that there's sufficient probable cause to go forward with the case. I want you to know now that the Texas Constitution does not allow me, but in very, very limited circumstances, to have a hearing to hold someone at no bond. You are now charged with a violation of protective order, and I'm putting conditions on your bond now. If I find that you violate these conditions, I can have a hearing to hold you at zero bond, no bond, and I will do it in a heartbeat to protect every person in this county. Do you understand?
Yes, sir, I understand.
So the problem is that he's got an impeding breath, I guess, against the same person now, right?
Yes, Judge. Just for the court's awareness, with the complainant, she's not on the word or anything like that. I think counsel and I have agreed that, no contact is going to be best moving forward. There's some issues with the cases that we'll look over,
Okay.
but just wanted to bring that to your attention.
What about bond? Because we need to set a bond and,
There's a $5,000, or there's, I think they've requested a $5,000 bond.
okay.
I'm asking for a $1,000 bond. And if I may, Your Honor, during the altercation, I showed the state a video that shows her being very violent. And during that altercation, his Xbox was broken. So he's denying I don't know how Xbox works, and I don't know how Fortnite works.
Hey, you never played Xbox?
Judge, my
Is it a
10-year-old plays
PlayStation
it.
or an Xbox?
My 10-year-old plays it excessively, but
You've never played Xbox?
I
Come on.
don't. I mean, I've tried a little bit, but 2 minutes.
Oh, my Lord. I mean,
I can't, I just get killed.
help me. I know what you're getting for Christmas. It's not the worst in the world, Mr. Haygood, but no means no. And I want you to understand that we're absolutely serious. If I find that you try to message this person through any means, I'm going to put you in jail. Do you understand?
Understand.
I believe that everybody deserves a chance, but I'm only gonna give you one. I will not give you any more. Understand? So I'll set the bond at $3,000. I'm gonna grant you a PR bond today, but you're not gonna get another one. You will sign orders now not to have any contact with this person, not to use any marijuana, not to use any alcohol, illegal drugs. If I find that you're using, you pick up another case or you try to have contact by any means necessary, I don't care what it is, I will put you in jail.
Sure.
You understand?
I understand clear as day.
So it's a bond set at 3. PR bond granted. And then, so I'm going to have you monitored through pre-trial, so don't worry. So you're also not to be in possession of weapons as well. So you've got a lawyer, just listen to him. He'll take care of you, even though he doesn't play Xbox. And then just, you know what's right, you know what's wrong.
Yes, sir.
Okay, all right, good luck.
Thank you, Your Honor.
Thanks. Oh, it's 255-3122.
31.
Yeah.
Right. Oh, right.
Joe Cortez, Carbon.
Oh, I'm sorry, Mr. Burns. Let me just, you're next. Okay, come on up, sir.
255, 31.
So, what was the last name?
Cortez.
Cortez.
You are Joe Cortez?
Yes.
Mr. Cortez, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 4th, 2025, in Harris County, Texas, officer was dispatched to a disturbance call and made contact with the complainant witness, who stated that the complainant witness is her father. The complainant witness stated that her father had arrived and was attempting to load a shotgun as he was upset from a previous incident.
He was loading a shotgun?
Stated that a witness, her grandmother, and her were attempting to take the shotgun from him when the defendant hit the complainant on her left eye multiple times with a closed fist, causing pain. She stated that as he was holding the shotgun, the defendant stated to her that he was going to kill her, grappling his hands against her neck, applying minimal pressure as she was blocking his hands. The witness stated that the defendant had been upset due to a car accident and that today he was loading a shotgun. And when her and the complainant attempted to take it away, the defendant hit the complainant in the face multiple times. Officers observed the defendant as he was still holding a shotgun shell in his hands when officers arrived and observed a red mark on the complainant's left eye and forehead area.
He's currently unemployed and lives with CW, Judge. That's as far as I got with him in terms of anything going for him.
I got to tell you, your lawyer wants me to give you a PR bond, but Mr. Cortez, I got to tell you, you scare me, dude. You're on bond for a DWI third right now. You're allegedly loading a shotgun. You've got all this. You scare me. The last thing I want is more blood or a dead body, you know? So don't say anything. I'm just telling you why I'm doing what I'm doing. Is my fear is that, you know, something even more egregious happens. If we give you a PR and you go back, there's nowhere else to go. And the last thing I want is a dead body. We have enough drama in this life as it is, you know? I'm sorry, man. I can't. It scares me. You know, I am ordering you now not to have any contact with complaining witnesses in this case and not to go within 500 feet of where they live, where they work. Do you understand? I don't know if you're going to bond out, but if you do, I'm putting a monitor on your ankle so I know that you're not anywhere near where these people live. Do you understand, Mr. Cortez? Life is too short to live the next 30 to 40 years in a 6x9 box. It's not. It's way too short. You understand? All right. Thanks. Okay. Ms. Burns.
Question on Jacob, was that pre-trial house convictions? What was his last name?
Yeah. So you have Cortez as well?
Yes, yes.
This is the case that we spoke about.
Exactly, last
the other day. Did something happen?
They were going to check upstairs. He had a pending felony as well, just to make sure that we were good to go with what we had discussed. And they said yes, so.
Okay, so you got the okay, I guess, right? Okay. Mr. Cortez, come on up.
Hey,
Yes.
Good morning, Mr. Cortez. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail with credit.
This is we're clean open to you.
Oh, you
We're not doing time served. We talked to you last week about playing open and a deferred.
It's not written as such then. Huh?
It's without a redirect.
Because look, it says 3 days credit.
Yeah, that's how it was. Yeah.
Oh, I see. Okay, so basically, essentially, I guess the state and your lawyer do not have an agreement as to what kind of punishment, so you're coming to me to punish you in this case. Are you okay with this?
John.
Okay, understand that, you know, it's a first DWI, you know, we're all allowed to make mistakes, right? We all make mistakes, everybody's human. But the problem is if you continue to make mistakes and you endanger other people's lives, that's when we have problems. And that's why we have harsher punishments, because we need to somehow get you to learn you can't keep doing this, because at some point, God forbid, something happens where you maim or kill someone. That's what we're trying to prevent. You have to understand that what we're doing now, the proverbial slap on the wrist, will not happen again. From now on, you're facing a minimum of 30 days in jail. Not only that, because this DWI is going on your record, if you get pulled over, an officer's going to run your record, they're going to see that you're a prior DWI. If you smell like alcohol, what do you think they're going to do? Probably right. So if I were you, even if you've had a sip of alcohol, I would never get into a car because it's a huge risk. Do you understand?
Yes, sir.
So I'm going to sentence you to 3 days in jail. I will give you credit for the 2 days that you've done. But like I said, from now on.
We were pleading to defer, Your Honor.
Oh, you want to defer?
Yes.
Oh, that's more different because here it says.
I don't know why the papers were that way. State offered time served. We were coming to you for deferred.
Okay. Is this what you want to do?
All right.
Okay, so this is a big difference, right? The deferred, and thank you for telling me.
Yeah, for probation.
So this is a probation where you must complete several things, right? If you do it, then good things will happen, right? What? Okay, so I guess we'll do 180 days. Probated for, I'm sorry, so we'll do deferred for 1 year. As part of the probation, you must complete a DWI education class. You must do a victim impact panel. You must maintain a guardian interlock throughout the entirety of this case. No drugs, alcohol, random urinalysis. So anything else that you would want?
Community service, did you already say that?
I mean, what does community service do? You know, I'd rather have him take a class and learn something than just mindless, just. Do you have any children, Mr. Cortez? Do you have any children?
Kids.
No? Okay, I'm just gonna do just these, even though you're doing a deferred, officers will still see this. You get pulled over, they're probably still gonna give you a hard time regardless. So, but regardless, whenever, no matter how old you are, no matter where you go, you're on a date, you're with the Queen of England, if you have something to drink, don't get into a car. Do you understand? If you violate this probation by testing dirty, picking up a new case, you don't do your stuff on time, I will issue a warrant and we will have a hearing to determine whether you violated this probation. If you do, you're looking at 180 days in jail. Do you understand? All right. How do you plead to the offense? Guilty or not guilty? I'm not going to find you guilty. I will withhold it for 1 year, get everything done, and then things will go well for you. Is that it?
That's great, Judge.
We done?
Yeah. Thank you.
All right. Good luck to you, sir.
Thank you. All right. See you later.
You can wait it.
Okay, we're going to go ahead and leave it there for today at the Courtroom Files Live. Thanks again for joining us as you did yesterday. Day 2, less bumps. Not as exciting of a court day, though. Towards the end there, we stuck with Judge Fleischer most of the time because pretty much everybody else fell silent. Really wanted to watch more Judge Simpson today because he had a lot of defendants moving through, and it would have been intriguing, but he kept muting Every time I was ready to cut to him, he silenced the feed. So sometimes it rolls like that. But anyways, we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. Thanks again for joining us. Please do put a thumbs up on this live stream if you enjoyed it. Tell your friends. We are a fast-growing channel, but the live stream is something totally different, and the best way we can grow is with your help and letting other people know about us. So appreciate it. Take care. God bless.